This week, the judicial branch tried to declare that all illegals have to get you have to get a warrant before you can arrest or seize them, according to one court. Another court said that you can't spend any money without our approval or authorization as it relates to foreign grants and foreign media and propaganda and censorship campaigns, that you need their approval, but in terms of personnel decisions. I mean, the one federal court basically took over the Border Patrol in the Central Eastern District of California. Just said, you have to approve everything, not only with us, but with plaintiff's counsel. You now got to get approval from plaintiff's counsel before you can do your job. That's how utterly insane these judicial rulings are. Also, they freed the radical. They said, oh, there's no risk of flight or anything else, which is not a judicial determination to make in the immigration context. That's an executive branch decision. But they don't care. They're just breaching every standard of care, every legal limitation, jurisdictional restriction possible. They also said President Trump can't, on the federal government's election form, simply answer the question that is required by federal law, that only citizens vote in federal elections in America, that he can't even ask that question on the federal voter registration form. Another judge said he has to allow the deep state law firms to maintain a shadow government and have secret access to secret files and classified information. Said he couldn't even overturn who has access to classified information. That's how insane the judges have been over the last week. Now, he got a good ruling from the D.C. Appellate Court, and there are multiple decisions pending before the Supreme Court that can impact all of it.
Let's start with, if we start with the, well, let me ask you this. Adam Kinzinger gets on Katie Couric and says, I didn't know that you weren't allowed hiding someone if the feds were coming. That's really chilling. Is that if the cops come to my house and ask me if I'm harboring an illegal, a fugitive, that I can't lie and say he's not there? When they come for, hypothetically, the illegal alien in the Dugan case, the judge, do they have a procedural warrant, or do they have an official warrant? Or at one point we distinguished between a show me the warrant versus a procedure of deportation. What do they have in terms of lawful, compelling, or producing the appearance of the illegal alien that Judge Dugan defied? Was it an actual warrant?
No, it's an administrative warrant. So the question of whether the Fourth Amendment, and like the Eastern District of California judge was such a fraud, she stated that the Supreme Court almost 50 years ago made it clear that the Fourth Amendment applies to illegals in America. It's a completely false statement. She just lied about the law, because in fact, that is an unresolved question. I'll give you the Supreme Court said in the 90s, said the Fourth Amendment does not apply to non-resident aliens unless they're inside the territory of the United States and either were here lawfully or have a substantial connection to the United States. They said, so the first question you look at the Fourth Amendment is, who are the people in the Fourth Amendment, right? So the Fourth Amendment to the United States Constitution provides for protection only to one group, the people, not persons, right? Notice the difference, right? There's different verbiage used in different parts of the Constitution. It says the people. So the question is, who are the people? By the way, the same liberal judges that are saying that the Fourth Amendment applies to everybody also turns around and says the people in the Second Amendment is very limited. That's funny. Same words, aren't it? The people. That's where if the people. Now, what the Supreme Court said was the people refers to the national community of people that have a sufficient connection lawfully to the country. Now, the decision was all over the place. There were like 6 concurring decisions. It's one of those deals. The original decision, 1975, that the district court cited in the Eastern District of California, that decision was a completely split decision. All they ruled in that case was that before you pull over a citizen, you have to have reasonable suspicion. The fact that you have reasonable suspicion that the crime the citizen committed relates to illegal immigration does not remove the constitutional protection for that citizen. That's all they said. There were 6 concurring opinions, or 6 judges signed on to concurring opinions. So there was no even controlling decision in the case. That's the decision the district court and a bunch of district courts are falsely reciting by false advocacy from the ACLU and others to argue that, oh, the Supreme Court's been clear that everybody has complete due process protection. Everybody has Fourth Amendment protection. Everybody has Fifth Amendment protection. Everybody has jury trial. Not true. So the next case, the Supreme Court, here's the quote. Aliens receive constitutional protections when they have come within the territory of the United States and develop substantial connections with this country lawfully.
Lawfully being the key word. And now that you mention it, Robert, like, because this example I always use is the Second Amendment is not afforded to illegal aliens or non-residents.
And what's the words that they use?
The people, a well-regulated militia
same
being
words
necessary
in the Fourth Amendment.
The
so
right
the
of
people in the Second Amendment should mean the same thing as the people in the Fourth Amendment. And the people in the Second Amendment has been limited to say non-resident aliens and illegals don't have Second Amendment rights. If they don't have Second Amendment rights, guess what? They don't have Fourth Amendment rights. It means they have no right to challenge anything. Now, there's multiple other issues with what the judges are doing. So the immigration, so constitutionally, the courts have previously allowed no warrant to be required to seize an illegal alien, to detain an illegal alien. The only decision they're citing is saying you can't detain a U.S. citizen merely because the crime might involve illegal aliens. The only other case is said illegal aliens have the same rights as anybody else when they're accused of a crime. But they've made clear that deportation is not criminal and is not punishment. So it doesn't apply to deportation. So then you have the second level of Supreme Court analysis, which has consistently held that the only due process that is due, the only process that is due because of the property and liberty interest is reduced for those who are illegally here, is what Congress legislates and the executive branch affords. That's it. They've said repeatedly there is, quote, no judicial role. And yet all these courts are jumping in. So what did Congress require? Congress just requires reasonable suspicion, requires you don't have to have a warrant at all. You can arrest, period. Right there. You have reasonable suspicion, you can stop and detain and physically arrest them. You need probable cause before you're going to arrest them without a warrant. If you're going to take them into custody, then you need probable cause just that they're here illegal. That's it. And you don't need a warrant for that beforehand.
Let me stop you there. That's going to be the sticking point. What would be the probable cause that someone is here illegally? Some people are going to say, oh, anybody who's speaking Spanish is going to be, a threat. I would imagine.
Yeah, no, it's got to be other things. But here's the question. How is that supposed to get processed? So the other things Congress has said is that there's no role for the courts in this until the very end. So they've said all of this has to be adjudicated through the removal process. If you believe your Fourth Amendment, or you believe you have any Fourth Amendment rights, or you believe there are any such rights violated, or your due process rights are violated, or anything else, then, or there was no reasonable suspicion or probable cause to arrest you, you have to go through the immigration process, which is controlled by the executive branch, and only then can you ask it be reviewed. And by the way, not by a district court. You can only have it reviewed by the courts of appeals in the jurisdiction where your removal took place. So the first question I had when this judge was issuing this order saying you can't arrest anybody without an arrest warrant or probable cause, and you have to give me permission, I have to give you permission before you even do your duties, and you have to report to law enforcement everything you're doing, and law enforcement has to report to the plaintiff's lawyers everything they're doing and getting their pre-approval for things. Utterly insane. Is that the district court has no jurisdiction. This is made very clear by the Immigration and Naturalization Act. Federal court, for Congress controls what powers any court other than the Supreme Court has. Supreme Court's given power by the Constitution. Every other court only has the power Congress affords them. So Congress made clear in the Immigration Naturalization laws, courts have no role here. So it's like, how did she pretend to have no role here? Here's the myth they're doing. They're saying that they admit and acknowledge that if the case concerns removal of an illegal, they have no jurisdiction. So how do they have jurisdiction? They're saying this case doesn't concern removal, even though it was an arrest for the purposes of removal. It's like, okay, you're completely eviscerating all of the principles that the INA established. What is this is what liberal courts will do constantly, any courts will do constantly, is unless Congress makes clear, you don't have power to do this in such unalterable language that even they have to concede, they will find ways around rewriting and weaseling interpretation to somehow say, yes, we still have jurisdiction. This is why Senator Mike Lee, to his credit, based Mike Lee on the internet, has become a really good populist, liberty-oriented advocate from Utah, who the deep state tried to take out, by the way, in his last election. That was a sign he was legit, was who was coming after him. He's going to pass bills that make it clear there's no question whatsoever that the federal courts have no jurisdiction whatsoever. Federal district and appellate courts, only the Supreme Court, have no jurisdiction if the issue concerns illegal immigrants. If the person cannot claim that they are legally present in the country, then they cannot bring any claim to the federal district courts will be stripped of all jurisdiction. That's what they have to do, because these judges are completely ignoring the limited role in this. Because, like, you go back, she basically said that there can't be an arrest without a flight finding, and that you have to confirm the flight finding with the plaintiff's lawyers and the court. It's like, well, what the hell are you doing, taking over the president's job? That's how insane this is.
They want to create 20 million administrative nightmares in order to be allowed to deport any of them. So create a problem.
By the way, a liberal dissenting judge in another case said the reason why you should allow employees to circumvent the Merit Service Board and all the laws governing them, this liberal Democratic judge in D.C. who dissented said, is because you can't expect these administrative bodies to handle 1,000 claims, but the same courts are demanding even more strict procedural requirements for 20 million illegals. That tells you what a fraud many of these judges are. The other component with this is that the judge is abusing class certification principles. Here she took one of the rules of class certification is you can't presume the merits are correct in order to get the class certification. So here's like a legitimate class certification is all truck drivers who are between the ages of 18 and 23 who are subject to, say, age discrimination claims. But what it is the class is the people who suffered the same injury from the same event of commonality. What you can't do is bury in it, the class is all the people who've been discriminated against. Okay, no, now you're presuming the merits in your so-called class. That isn't how class certification is supposed to work. It's supposed to be common questions of law and common injuries that predominate in the case, sufficient to make it more efficient to have a class. And here you had it was like, who's the class? The 3 guys that got pulled over that are objecting to getting pulled over? It's like, okay, that's just 3 people. How do they represent a class of people that could possibly ever be subject to any kind of restriction by the Border Patrol in the future? It's like, that would be too big of a class. So what does the judge do? The judge says the class is anybody whose rights are being violated, which is a direct violation of the judge's own jurisdiction on class actions. So they're abusing their power on nationwide injunctions. They're abusing their power on class actions, and they're abusing their power in contexts that are given exclusively to the executive branch. Those are the most egregious forms of abuse of power by all these district court rogue rulings. And the utility is they're bringing up to the Supreme Court unresolved questions that long needed resolution. And the Supreme Court's going to restore Article 3 balance to the system by restoring Article 2 power to it and respecting it and recognizing it officially in presidential decisions in the context of immigration, in the context of policy, in the context of personnel, the context of funding, in the context of all of these and classified information and who has access to it, all of these rogue efforts to overturn an election and usurp constitutional powers of the elected president of the country. Or they will fail to, and then Congress will be put in a position where it has to pass reform. Current legislation's already passed the House, drastically limiting the ability of federal courts to ever issue any nationwide injunction in the future. Senator Lee is now proposing stripping them of all jurisdiction in any matter that concerns immigration. The president and Congress are considering suspension of habeas corpus for the purposes of illegal immigration, which, by the way, we talked about 2 weeks ago. Other people picked up on it, asked Trump about it. Now Trump is considering discussing it, thanks to this community putting the word out there. So I think those are the kind of reforms that are going to happen. And already there are other cases before the Supreme Court concerning the substantive merits. One little tidbit. Why is the United Food Workers joining these cases? And I say this as someone who interned for the various farm and food and commercial workers back when I was a young student at Yale and at the AFL-CIO in D.C. Cesar Chavez was opposed to illegal immigration. Go back and read his statements about it. Why are they joining cases to promote illegal immigration that replaces their workers, their unionized workers, and the benefits of those unions in Central California? Well, it shows you how these unions have been corrupted and co-opted by union leaders that are breaching their fiduciary duties and obligations to their own workers to promote an ideological agenda that is economically against their interest and culturally and politically exactly the opposite of the great founder, Mr. Chavez.
Well, I mean, I think also Adam Kinzinger explained it very well to Katie Couric when he said, "Why were there so many Haitians in Springfield, Ohio? It's because they needed the manufacturing labor, which is a load of crap. They had cheap, foreign, unskilled labor of people who didn't speak the language of the land that they could exploit like modern day slaves." But I mean,
And they get to inflate inflate states with more electoral votes and more congressional votes than they should have, more congressional representatives than they should
yeah.
have, because illegals are counted in the census. And Trump's effort to prohibit that was stopped by the rogue Supreme Court. Now, two other components. Prior decisions give some preview of where the courts are probably going to have to go on this, Supreme Court. Justice Kennedy, in his concurring opinions, talked about in immigration law, you need to do what's, quote, you need to make sure that your principle of constitutional application is not, quote, impracticable and anomalous. He was saying this in particular in the immigration enforcement context. It is complete, as you know, it is completely impracticable to require that 20 million illegals receive the same degree of due process as if they legally entered the country and had legal rights to be here, because that would so gum up the system that you would be unable to effectively deport anybody. That's what the federal district court's really trying to do in California by imposing supervisory control over the day-to-day regulatory actions of an agency based on a bogus constitutional premise and a unlawful jurisdictional assertion and a rogue class certification, all of which violate and contravene the various laws at place. In addition, you have Justice White, who said, this is immigration, let's leave it to Congress and the White House. You're going to see a strong move there. Then you're going to have it was Scalia who led the way on the idea that the people under the Fourth Amendment did not include people who are illegally present here in the country. And so you're going to see conservatives start to go more that route because they see what a disaster this has been, what a political disaster and chaos they are producing.
I've got the catchphrase: you cannot steal constitutional rights. Bada bing, bada boom.
Yeah.
Okay, we'll put on a mug.
There you go. That illegals have no due process rights with respect to their admission is something the Supreme Court has consistently held. So the same logic applies when they came in illegally to begin with. Now, the other factor here is the exclusionary rule. I would note they have said that even if the government violated the Fourth Amendment, that in an immigration context, because it's a civil proceeding, the exclusionary rule doesn't even apply, by the way. So again, these are rules meant to protect people lawfully here, people who have a lawful right to be here. The Supreme Court has never said that those who have no legal right to be here are entitled to the same due process as those that are legally here, are entitled to any protection under the Second Amendment or Fourth Amendment to the U.S. Constitution. And that's where the egregious breaches are reoccurring. And these other Supreme Court cases will actually provide a vehicle for the court to start to clean up this nonsense, because if they don't, either congressional reform is incoming or presidential refusal is incoming.
Amazing.
Okay. One last component.
Yeah.
Best way if you're out there arguing with someone or normie, here's the kind of people they've said don't have Fourth Amendment rights: prison escapees, parolees, trespassers on land. What is an illegal immigrant in the country? Basically worse than a parolee, a lot like a prison escapee, and exactly the same as a trespasser. Why? Because it's not that they're not within the people. That's one way. But they say they don't have any Fourth Amendment legally recognizable privacy interest, because you have no privacy interest in trespassing. You have no privacy interest in being an escapee. You have no private interest in being a place you have no business being in the first place. So that's the other way in which they don't have Fourth Amendment protection of the kind that these courts are trying to impose.
Well,